He's the first U.S. president ever convicted of a crime, 34 felony counts, a historic guilty verdict that made headlines around the world. But Donald Trump is now president again, and his lawyers have been fighting tooth and nail to overturn his conviction, or at least move it to a court more favorable to him. On Wednesday, February 5, 2026, a federal judge heard Trump's latest legal maneuver. The goal? Move his New York State conviction to federal court, where it could be fast-tracked to the conservative majority Supreme Court. But the judge wasn't buying it. You made a choice. You sought 2 bites of the apple, Judge Alvin Hellerstein told Trump's lawyers. And those words may have just sealed the fate of Trump's appeal strategy. This is Breaking Worldview, and today we're breaking down the latest chapter in Trump's hush money case. What happened in court, what it means for the conviction, and what comes next. Let's dive in. To understand what happened this week, we need to go back to May 30th, 2024. The verdict. A jury of 12 New Yorkers found Donald Trump guilty of 34 felony counts of falsifying business records. The charges stemmed from a scheme to influence the 2016 presidential election by covering up hush money payments to adult film actress Stormy Daniels. Here's what prosecutors proved. In October 2016, just weeks before the election, Trump's personal lawyer Michael Cohen paid Stormy Daniels $130,000 to keep quiet about an alleged sexual encounter with Trump in 2006. Trump has always denied the affair. After Trump won the presidency, Cohen was reimbursed, but the reimbursement was disguised as legal fees in Trump's business records, falsified invoices, ledger entries, and checks that made it look like routine legal work when it was actually hush money repayment. The jury heard testimony from Michael Cohen, Trump's former fixer, Stormy Daniels herself, Hope Hicks, Trump's former White House communications director, financial records experts, witnesses who described the catch-and-kill scheme. The verdict was unanimous, guilty on all 34 counts. Trump faced up to 4 years in prison, but he had something most convicted felons don't have, a presidential election to win. The sentencing. Trump won the 2024 election in November. He was set to be sentenced on January 10th, 2025, just 10 days before his inauguration. Trump's lawyers launched a last-minute blitz to stop it. They appealed to Judge Juan Merchan, denied. They appealed to New York's Appellate Division, denied. They appealed to New York's Court of Appeals, denied. They appealed to the U.S. Supreme Court, denied 5-4. 4 conservative justices, Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh, wanted to block the sentencing, but Chief Justice John Roberts and Trump appointee Amy Coney Barrett joined the 3 liberal justices to let it proceed. On January 10, 2025, Judge Merchan sentenced Trump to an unconditional discharge. What does that mean? No prison, no fines, no probation. Just a permanent criminal record. Merchan called Trump's actions a premeditated and continuous deception by the leader of the free world. Trump attended the sentencing virtually from Mar-a-Lago. 10 days later, he was inaugurated as the 47th President of the United States, the first felon to serve as president in American history. But Trump's legal team wasn't done. The Supreme Court's immunity ruling, on July 1, 2024, just 1 month after Trump's conviction, the U.S. Supreme Court issued a landmark ruling in Trump v. United States. The decision involved Trump's federal criminal case related to January 6th. The Supreme Court ruled that presidents have presumptive immunity for official acts taken while in office. This was a huge win for Trump. It effectively killed the federal January 6th prosecution. But here's the question. Could this immunity ruling also apply to the New York hush money case? Trump's argument, Trump's lawyers say yes. Here's their logic. During the hush money trial, prosecutors introduced evidence involving Trump's time as president, tweets Trump sent from the White House testimony from Hope Hicks about conversations in the West Wing discussions with White House counsel about the hush money scandal. Trump's lawyers argued these were official acts protected by presidential immunity. Therefore, prosecutors shouldn't have been allowed to use this evidence. And if the evidence was improper, the entire conviction should be thrown out. The strategy, Trump is pursuing 2 parallel appeals, state court appeal, going through New York's appellate system, which could eventually reach the U.S. Supreme Court, but would take years. Federal court removal, trying to move the case to federal court, which would provide a much faster path to the Supreme Court. This second strategy is what brought Trump's lawyers to court on Wednesday. Previous attempts, Trump has tried to move the case to federal court 3 times. First attempt, before trial. Judge Alvin Hellerstein denied it, ruling that hush money payments were private, unofficial acts outside the bounds of executive authority. Second attempt, after conviction, after immunity ruling, Trump tried again. Hellerstein denied it again, writing, "Private schemes with private actors, unconnected to any statutory or constitutional authority or function of the executive, are considered unofficial acts." Third attempt, after appeals court order, and the Second Circuit Court of Appeals told Hellerstein to take another look in light of the Supreme Court's immunity decision. That's what happened Wednesday. On Wednesday, February 5, 2026, Trump's lawyers and Manhattan prosecutors faced off in front of Judge Alvin Hellerstein in federal court in Manhattan. Trump's argument: Jeffrey Wall, Trump's attorney, made the case when the Manhattan District Attorney's Office introduced evidence of what they argued were official acts, such as Trump's tweets, trial testimony from his former White House aide Hope Hicks, and testimony about conversations Trump had with his attorney general. This became a prosecution relating to those official acts. Wall argued that once prosecutors used evidence covered by presidential immunity, the entire case became tainted and must be moved to federal court. He also addressed the timing issue. Trump waited 58 days after the Supreme Court's immunity decision before filing his federal court motion. The standard window is 30 days. Why the delay? Wall explained it would have been disrespectful in spades to Judge Merchan if Trump's lawyers had bypassed the state judge and gone straight to federal court. They had to give Merchan a chance to rule on the immunity issue first. Trump was set to be sentenced just 10 days after the immunity ruling, so they had to move fast in state court. It is what any sensible litigant would do, Wall said. The judge's response: Judge Hellerstein was not impressed. On the timing issue, you waited too long. You didn't have to go through a motion before Judge Merchan. Whether Judge Merchan would have been pleased or displeased is totally irrelevant. You intended to litigate in state court. Only when you sensed disappointment did you revert to an effort to have a federal forum. You made a strategic decision. You're seeing where you can get a better decision, and that is indicative of the intent. My thesis is that was fatal to you. On trying multiple courts, you made a choice. You sought 2 bites at the apple. This was the key line. Hellerstein accused Trump's lawyers of forum shopping, trying the argument in state court, and when that didn't work, trying it again in federal court, trying it again in federal court. On the evidence, Hellerstein questioned whether the communications introduced at trial had anything to do with official presidential duties or were just embarrassing for Trump. The telling part of the evidence was the falsification of the records themselves that had nothing to do with any kind of White House directory or official records. On what would happen next, Wall conceded that if the case moved to federal court, there would be nothing for Hellerstein to do except adopt the state court judgment and send it to the Second Circuit Court of Appeals. On we go to the Second Circuit. You'd be done with this in a day, Wall said, but Hellerstein appeared unmoved. The only thing you want me to do is adopt the New York Supreme Court judgment as mine. In conscience, I can't do that. The prosecutor's argument, Stephen Wu from the Manhattan District Attorney's Office, argued, the Supreme Court immunity opinion only affects the admissibility of evidence, not the charges themselves. The charges had nothing to do with Trump's official conduct. The falsification of business records happened before Trump even became president. The scheme was about influencing the 2016 election, a campaign matter, not a presidential function. Wu argued that the advanced stage of the case, trial completed, verdict rendered, sentencing done, appeal already pending in state court, weighs against moving it to federal court now. The ruling, Judge Hellerstein did not issue a ruling from the bench. He said he found the arguments provocative and would issue a decision later. But his skepticism was clear. Legal experts watching the hearing said Hellerstein appeared very unlikely to rule in Trump's favor. So what does this mean? Let's break down the legal implications. 1. Trump's strategy. Trump's goal is simple. Get to the Supreme Court as fast as possible. Why? Because the Supreme Court has a 6-3 conservative majority. 3 justices were appointed by Trump himself. 4 conservative justices already voted to block his sentencing. If Trump can get his conviction before the Supreme Court, he has a reasonable chance of getting it overturned based on presidential immunity. The state appeal process could take years. Moving to federal court would be much faster. 2. The timing problem, but Hellerstein identified a fatal flaw. Trump's lawyers made a strategic choice to go to state court first. When that didn't work, they tried federal court, 58 days after the immunity ruling, well past the 30-day window. Their excuse? They didn't want to be disrespectful to Judge Merchan. Hellerstein essentially said, that's your problem, not mine. You made a strategic decision, and now you have to live with it. 3. The official acts question, at the heart of this case, is a fundamental question where the apterwa sing where the amwarates, I feature the ops protected by immunity. Trump's tweets as president, his conversations with Hope Hicks in the White House, Trump's lawyers say yes, anything done while serving as portraits. In a White House, Trump's lawyers say yes, anything done while serving as president is an official act. Prosecutors say no, covering up hush money payments to a porn star is not a presidential function. The fact the White House staff were involved doesn't magically transform a personal scandal into official business. Judge Merchan already ruled on this, finding that the hush money statutory or constitutional authority. Hellerstein and Kittrine already ruled on this. 4. What happens if Hellerstein denies the motion? Trump can appeal to the Second Circuit Court of Appeals, but that could take months. Meanwhile, his state court appeal is already proceeding. That will go through New York Appellate Division, New York Court of Appeals eventually, potentially the U.S. Supreme Court. But the state route has additional layers of review and will take much longer. 5. Can Trump pardon himself? No, this is a state conviction, not a federal one. Presidential pardons only apply to federal crimes. New York Governor Kathy Hochul could theoretically pardon Trump, but she has shown no indication of doing so. 6. The unconditional discharge. Here's the irony. Trump received the lightest possible sentence. No prison, no fines, no probation. Judge Merchan specifically chose this sentence to avoid interfering with Trump's presidential transition and duties, but the conviction remains on Trump's record. That's what he's really fighting. 7. Presidential immunity. While in office, as sitting president, Trump is largely shielded from criminal prosecution for the duration of his term. The appeals process will continue, but enforcement of any consequences is effectively on hold. This case raises profound questions about presidential accountability in America. Question 1. Can a president be held accountable for pre-presidential crimes? Trump committed these crimes. When he to the jury before he became president. The falsification happened in 2017 during his first term, but the underlying scheme was about the 2016 election. If presidents can't be prosecuted for crimes committed before taking office, what does that mean for the rule of law? Question 2. What are official acts? The Supreme Court's immunity ruling created a new category of protected conduct. But where's the line? Is a president's tweet always an official act? What about conversations with staff about personal scandals? Trump's lawyers are pushing an expansive view. Anything done while serving as president is official. Critics say this would give presidents immunity for virtually any misconduct, as long as they discussed it with White House staff or tweeted about it. Question 3. Does timing matter? Trump's lawyers argue they had good reasons for their timing. They were being respectful to the state judge. They were under time pressure with sentencing approaching. But Judge Hellerstein sees it differently. They made a strategic choice and are now trying to undo it when it didn't work out. Who's right? The judge will decide. Question 4. Is this about justice or politics? Trump and his supporters argue this prosecution was politically motivated from the start, a Democratic DA in a Democratic city going after a Republican president. Prosecutors counter that Trump was treated like any other defendant. A grand jury indicted him, a jury of his peers convicted him, and the judge gave him the most lenient sentence possible. Where's the truth? Reasonable people disagree. Question 5. What precedent does this set? If Trump succeeds in overturning his conviction based on presidential immunity for evidence involving his time in office, what does that mean for future presidents? Could a president commit crimes, discuss them with staff to create official act evidence, and then claim immunity? The implications are far-reaching. So where does this leave us? Judge Hellerstein will issue a ruling later. Could be days. Could be weeks. Legal experts predict he will deny Trump's motion to move the case to federal court. His skepticism was clear. If that happens, Trump will appeal to the Second Circuit. That process could take months. Meanwhile, his state court appeal continues through New York's system. Eventually, maybe in 2027, maybe 2028, this case could reach the U.S. Supreme Court through one path or another. Until then, Donald Trump remains the 47th President of the United States, the first president ever convicted of a crime, a man with 34 felony convictions on his record, but no prison time, no prison time, no fines, no probation. The conviction stands. The appeal continues. And the legal battle is far from over. The fundamental question, at its core, this case asks, should a president be above the law? Trump's lawyers argue that presidential immunity is essential to protect the office from politically motivated prosecutions. Prosecutors argue that no one, not even a president, should be exempt from accountability for criminal conduct. The courts will ultimately decide. And whatever they decide will shape the American presidency for generations to come. This has been Breaking Worldview, bringing you the facts behind the headlines. If you found this legal analysis valuable, please like, subscribe, and share. Let us know in the comments, do you think Trump's conviction should stand, or should presidential immunity apply? Thanks for watching. We'll keep following this story as it develops.